So I welcome you all. Let's start this discussion together so we can have a good and some healthy discussion on related to something related to IBC and how IBC in theory is different from the practical aspect. So everyone, nowadays you mostly they are fifth year students, and I'm sure they must be having their insolvency and bankruptcy code in their last semester or ninth semester, right? So after a few months, you are going to join your career either in litigation or corporate or wherever, and many of you are having interest in IVC, right? So the theory we read in the books and the practical steps which while we go for practicing, the challenges we face there, and the scenario is something different from the book. Everything is completely different from the books and in practicality. So we need to understand that differences. We need to understand how real life is different from the theoretical life. How practice is different from the theory. It's not the straightforward line. We read in book ki yeah, insolvency should be completed within 180 days, right? It's the as per IBC code, it should be completed within 180 days plus 90 days extension, so maximum 270 days. But in practicality, it does not happen that. In fact, in various judgment court has allowed the maximum extension up to 330 days. But also, again, no CRP can complete in 330 days. There are one or two or three maximum cases in out of 100 that get completed within the time period. So there are various gaps between the theory and the practical life. So we need to discuss all those things today and how it's different. And from the student's point of view, we will be also covering some landmark judgments and recent amendment or the what kind of question can be asked in your exam. We will be covering all those aspects as well. So I just wanted to confirm any students who are here from the fifth year or who is having interest in the IBC. So I mean they can raise their hand or they can unmute yourself and they can tell me. So that I just wanted to make this session more interactive, more engaging, so that the students and me can connect easily. And they also can feel free so that they can ask any kind of doubts they have. So we are here as a friend, as your mentor, not as a teacher or lecturer. So I just want to make it more engaging session so that I can clear your doubts, right? So let's start the session. So today we are discussing about IBC. So let me tell you the purpose of IBC, why IBC has been, formed, how, why it's important in today's era for today's country's development, economic development, how it works, and what's their role. So the purpose of IBC is to restructure the company, not to recover from the any debtor. The main purpose of the IBC is to restructure the company, to restart the company from scratch. Those company who have been went into CIRP. So early before IBC, there were several acts like SARFAESI, BFI Act, and Companies Act. There are several acts who govern insolvency and bankruptcy. But in year 2006, the Indian government came up with a new code, that is Insolvency and Bankruptcy Code, which is a well-established code and it's a cover every whole CRP liquidation, everything including binding up covered under this IBC code. But before this, there were several acts which was governed by them. But now, from the 2016, the new code has been came into force, and this code covers everything. But there are several gaps. Still, there are several gaps, and this code is still evolving. Recently, also amendment has been proposed. It's still pending in the select committee or the review committee before the parliament. So there are some gaps which is going to be fulfilled, but there will be again some gaps which we need to point out and we need to put forward before before the society, before the legislature, so that that gaps can be fulfilled. So we will be now discussing about how IBC works. So in IBC there are three things: one creditor, one debtor, and one is the adjudicating authority. The creditor is someone who gives the debt, and the creditors can be in two forms. Either it's the financial creditor, those who lend money directly, or the second is operational creditor, those who provide services or goods instead of money. They are considered as a operational creditor, and those who lends money directly is a financial creditor. Apart from that, there are creditors like government dues. They are also an operational creditor. But the major two creditors are financial creditor and operational creditors. Those who lend money is a financial creditor. Those who provide service or goods is a operational creditor. So there are different process for both of them for filing an application. Financial creditors can file application under Section 7. They need to just give that agreement or the proof of that financial debt. If there is a loan agreement, if there is a debt that has been marked before the authority. So, and there is a operational creditor who have lend provided goods or services. They have invoices or they have demand notice or invoices or demand notice that have to be present before the filing before the NCLT. So the difference between operational creditor and financial creditor is that when it comes to the insolvency after initiation of CIRP, when company goes into CIRP, IRP appoints, and the role of the IRP is to first their job is to make a public announcement. Within 14 days, they make a public announcement that this so and so company has been went into a CIRP, and anyone having any claims can file their claim before the IRP. So IRP consolidates that all claims, make a list of creditors depending on their nature of debt, whether they are financial creditor or operational creditor, and on that, based on those who all are the financial creditor from that list, that made to be the member of COC. That is the Committee of Creditors. COC member has been formed. After that, the duty of COC member is to regularize the IRP into RP or to replace the IRP as a new RP. So after constitution of COC, the first duty is to replace or to appoint new or to continue with the same IRP. So after that IRP appointed, then now the role of IRP is to take control over the company. From every aspect, the control of the company is with the hand of RP, who will be controlling the company with in consultation with the COC members. The COC will be the main person, that the committee will be committee will be heading that every decision of RP, and the RP will be representing on behalf of COC while taking all the decisions. So the role of RP is not limited to only this aspect. The problem starts while the RP taking claims. They face many challenges. So there are several kinds of creditors who file claim. There are several kinds of home buyers who file claim. But challenges start from initiation. After initiation of CIP, every kind of problems being started. The delays process has been started from the very first day. There are several claims that need to be filed within. In general, we see the process is to file the claim within 30 days. But in practicality, it does not happen. जब थ्योरी पढ़ते हो तो उसमें ऐसा क्लियर मेंशन होता है कि you have to file the claim within 30 days, right? But in practicality, that does not happen. यहाँ पे claims is also filed even after 30 days. If RP or liquidator does not accept the claim within after 30 days, then the opposite party has right to move before the NCLT, and they get direction from the NCLT if there are certain difficulties due to which we were not able to find, we did not come to know about the insolvency proceeding. There's several kind of reasons. Based on that, their application get admitted and their claims has to be admitted by the RP. So that also caused delay in the process. But while we are studying in the books, it's clearly mentioned that the claim has to be filed within 30 days. So see how it is different from the practical life and it is different from the theoretical life. In theory, we have to follow 30 days rule, but in practicality, that does not happen. Even we have to, like I am handling more than 20 cases where I have seen there are several cases, there are several lenders, there are several operational creditor like government dues, GST department, income tax department, who come after more than 300 days, 190 days, and we have to accept the claim due to the order of the NCLT. That also caused problem and delay in the streamlining the process. So this is the difference between practical aspects and the theoretical aspects. So once this challenges we face this kind of challenge. Apart from that, the role of RP, once CRP initiated, moratorium period continues. Moratorium period means once CRP commences, no cases can be initiated against the corporate debtor. So who are the corporate debtor? Corporate debtor are the company or the person who have taken loan or against whom the case CRP has been initiated. That are known as corporate debtor. So once CRP initiated, no cases can be initiated against corporate debtor except criminal proceedings. Criminal proceeding is separate. criminal proceeding can be initiated. PMLA proceedings like money laundering matters can be initiated. That's also be considered as a criminal liability. So these kinds of matters can be initiated against the corporate debtor, but the civil kind of nature, any recovery proceedings cannot be initiated anywhere except before the NCLT, and that's related to only filing of claim or everything can be initiated. So once moratorium period initiated, no claims can be filed, and the RP has to admit all the claims, whatever are based on the documents, proof, and on the basis of that, the COC member will be formed. Now, the duty of RP is to perform in transparent manner. They cannot do the partiality कि हाँ उनका इस आदमी की क्लेम मुझे एडमिट नहीं करना है या उनका करना है. दिस हैज टू नॉट टू बी डन बाय द आरपी. अगर ऐसा कुछ भी होता है देन द एप्लीकेंट हैव राइट to move before the NCLT. On so and so ground, my RP has rejected my claim. And the NCLT have jurisdictions to entertain and to see whether this decision was true or not. The NCLT will be deciding those kind of challenges. Right. Again, the main purpose of CIRP or the RP, insolvency, is to revive the company, not to bind up the company. So in IBC, there are two things. One is CIRP, that is insolvency process. Second is liquidation. So liquidation is the last resort, means the binding of the company. Liquidation is the process where the assets of the company has to be sold by the liquidator, and those money, those funds needs to be distributed amongst the creditors and the other members like operational creditor, financial creditor, workman dues, or the statutory dues, every kind of dues, whatever they are, that has to be distributed by selling the assets of the company. But in CIRP, we do not do that. We try to get the company revived again, because the motive of the IBC is to revive the company, not to liquidate the company. So the motive is to revive the company. So for that, RP propose give and publish an EOI, expression of intent, that any member, anyone who wants to acquire the company, who wants to present an proposal, that is called RA, resolution applicant. Resolution applicant comes with a resolution plan that I will be taking over the company and I will be paying the debt of the company in this manner. There are several terms and conditions. There are several structure and process they have to follow, and that resolution plan needs to be presented before the COC members, the members who are who are leading that committee, and they will be deciding whether this resolution plan is beneficial for them or not, whether the terms and condition mentioned, whether the payment method or the amount which has been offered is sufficient or not. If the commercial wisdom of COC members seems fine, yes, this proposal, this plan is appropriate in terms for the every creditor, then they accept that resolution plan. If they find this plan is not appropriate, not viable, they reject the plan. Once you reject the plan, the company went into the liquidation. This is the theory. This is the complete theory. But in reality, what happens in 80 or 70 to 80% cases, resolution plan gets failed due to several reasons, due to several haircuts to the other members, due to the several structure of the payment, due to not viable. There are several reasons due to which the resolution plan did not get accepted, which leads to the company went into the liquidation. And the liquidation, once the liquidation process started, then this means the company needs to be bind up. But there are several other examples as well where the company get revived in liquidation as well. But I guess after this amendment, the code IBB has already implemented that now the company in liquidation has to be dissolved after selling all the assets. Now the company cannot be sold as a going concern. I'll come to this point as well. We'll make you understand how these things work. Now, first we will be discussing about CIRP and RP. So in CIRP, resolution plan being offered, when presented before the COC members, they need to check the viability of the plan. They need to check whether this plan is appropriate, whether this plan is sufficient to maximize the value. The main purpose of COC member is to maximize the value of the company. Then after they think about the रिवाइवल ऑफ द कंपनी। उन्हें चाहिए होता है कि भाई मेरे पैसे लगे हैं तो मुझे मेरे पैसे मिल जाए। एवरीवन जो कोई भी अपने पैसे लगाते हैं किसी कंपनी में तो उनका यही पर्पस होता है कि मुझे वो पैसे मिल जाए। तो सीओसी मेंबर्स ऑल्सो ट्राई टू डू दैट ओनली, बट उसी वजह से काफी टाइम पे कम ऑफर पैसे ऑफर किए जाते हैं रेजोल्यूशन एप्लीकेंट की तरफ से, जिस वजह से भी काफी सारे रेजोल्यूशन प्लान फेल हो जाते हैं, जिस वजह से सीआरपी को लिक्विडेशन के लिए ऑर्डर, आई मीन एनसीएलटी को लिक्विडेशन ऑर्डर पास करनी पड़ती है और कंपनी को लिक्विडेशन भेजना पड़ता है। लिक्विडेशन प्रोसेस में भी सेम है, सब कुछ आरपी को लिक्विडेटर की तरह रिप्लेस किया जाता है और न्यू लिक्विडेटर अपॉइंट किया जाता है। एंड आफ्टर दैट, the once the new liquidator take place, they do the same process like making public announcement, and then they accept the claims, and then they make this members committee, that is here now says that SCC committee, stakeholders consultant committee, that COC becomes FCC now. And now the same power, whatever the COC was having, the same power will be having with the SCC member. So the SCC members will now be taking all the decisions along with the RP. IRP will be putting their suggestion before this SCC members, and the SCC will be taking all the decision. They will have to vote in accordance to their claim. जिनके जितने परसेंट के क्लेम होते हैं उस अकॉर्डिंग उनके वोट होते हैं। एंड इफ कंपनी इज गोइंग टू बी लिक्विडेटेड, देन द ड्यूटी ऑफ लिक्विडेटर इज टू टेक कंट्रोल एंड कस्टडी ऑफ द एसेट्स। कंपनी के जितने भी एसेट्स हैं उसके कंट्रोल लेना, जितने भी प्रॉपर्टी है उसके कंट्रोल लेना। प्रॉब्लम अब आती है वाइल टेकिंग कस्टडी। तो जो एक्स प्रमोटर होते हैं कंपनी के, मीन्स डायरेक्टर, इन्वेस्टर, जो भी रहते हैं जिनके पास कंट्रोल होता है कंपनी का, तो दे क्रिएट प्रॉब्लम। उनके पास कंपनी के सारे डॉक्यूमेंट्स होते हैं, सारे पेपर्स होते हैं। द लिक्विडेटर फेस challenges while taking that document, recovering that documents from the promoters। उसमें काफी डिले होता है, जिस वजह से जो टाइम बाउंड मैनर है आईबीसी का वो फुलफिल नहीं हो पाता है। वो भी एक रीजन है डिले का। दूसरा, वैल्यूएशन। जब आप कंपनी के एसेट का कंट्रोल ले लेते हो अपने पास, तो हम उसकी वैल्यूएशन कराते हैं, वेदर कि अभी करंट मार्केट में इस प्रॉपर्टी की वैल्यू क्या है। अगर 1 एकड़ जमीन है किसी कंपनी के पास, 5 बिल्डिंग्स हैं, 2-4 फ्लैट्स हैं, 8-10 गाड़ियां हैं, तो अभी क्या स्टेटस है, क्या रेट है मार्केट में, उसके लिक्विडेशन वैल्यू क्या है। तो जो रजिस्टर्ड वैल्यूअर होते हैं हम इनको अपॉइंट करते हैं। दे आर प्रोसेस फॉर अपॉइंटिंग देम, एंड दे डू देयर जॉब वाइल मेकिंग अ डिटेल्ड रिपोर्ट, वैल्यूएशन रिपोर्ट, जिसमें हम एक वैल्यू लेके आते हैं कि इस एसेट्स की इतनी वैल्यू है। एंड देन वी ऑक्शन दैट प्रॉपर्टी इन पब्लिक पोर्टल। हम पब्लिक प्लेस पे उसको ऑक्शन करते हैं। ऑक्शन में जो बिड करके आता है, दे बिकम द सक्सेसफुल बिडर, एंड दे टेक ओवर दैट एसेट्स, एंड दे एंड that from that money we distribute among the stakeholders. Now the distribution, how distribution works. So as per section 53 there is a waterfall mechanism, जिसमें बताया गया है कि पहले किसको प्रेफरेंस मिलेगा, फिर किसको मिलेगा, फिर किसको मिलेगा। So I just wanted to know, anyone who have studied IBC can explain what is waterfall mechanism, या section 53, because it seems like I'm speaking and no response is getting. So I wanted to make it more engaging so that students can interact with us as well. तो थोड़ा काफी engaging सा सेशन होगा, आपको भी मजा आएगा, हमें भी मजा आएगा इस चीज को और कंटिन्यू करने में। Anyone?
The banks go first for the recovery, then the operational creditors, then the municipality and all the taxes, the government bodies are the last. This is the waterfall mechanism, I suppose.
Bit correct, bit correct. You are right. But I wanted to add something. So not only banks, any financial creditor, secured financial creditor, generally it's the bank, no doubt. But with bank, there are other financial institutions as well, like NBFC, non-banking financial institution, like Edelweiss, Asset Reconstruction Company, yeah, Birla Asset. There are several NBFC who also have the same, they also lend the money, they also get something mortgage, so they become the secured lender, right? So the secured lender who have charge over the assets, that become the secured lender, who have the first priority. But in that there are two kinds of secured lenders: one who relinquish their right, and one who did not relinquish their right. What that mean? The person who relinquish their right means the person by himself saying that कि मैं अपना उस एसेट पे जो चार्ज था, जैसे मान लो आप कोई लोन देते हो तो बदले में कुछ मॉर्गेज लेते हो, राइट? तो जो आप मॉर्गेज लिए हो, आप उस चीज को लिक्विडेटर के कंट्रोल में दे देते हो। दैट मीन्स यू हैव रिलिंक्विश योर राइट टू रियलाइज। अब आप उस एसेट को लिक्विडेटर रियलाइज करेगा। सेकेंड, दो क्रेडिटर हु डू नॉट रिलिंक्विश देयर राइट, वो क्या करते हैं, वो खुद से ही उस चीज को बेच देते हैं बिकॉज दे हैव राइट। तो रिलिंक्विश नहीं करके वो खुद से बेच देते हैं एंड वॉट एवर द अमाउंट दे गेट, उनकी जो रेशियो बनती है उस हिसाब से वो अपने अमाउंट रखेंगे, बाकी दे हैव टू रिफंड अगर ज्यादा है तो, और कम है तो कोई बात नहीं, वो जितना अमाउंट आता है वो उतना रखेंगे। सो दोज हु रिलिंक्विश देयर राइट दे हैव द फर्स्ट प्रायोरिटी, द सिक्योर्ड क्रेडिटर। देन द अनसिक्योर्ड क्रेडिटर, जो अनसिक्योर्ड होते हैं, जिन्होंने फाइनेंशियल डेट तो दिया है बट एज अ मॉर्गेज कुछ नहीं रखा है, so those they get the second priority. But before all these, on the equal footing, the secured creditor and the workman employees, the workman dues, जो कंपनी में काम कर रहे होते हैं पिछले 1 साल से 2 साल से, जो जिनकी पेमेंट नहीं हुई रहती है, उनको फर्स्ट प्रायोरिटी दी जाती है अलॉन्ग विद द सिक्योर्ड क्रेडिटर, वर्कमैन और एम्प्लॉयज उनको। बट बिफोर दैट, सीआरपी कॉस्ट या लिक्विडेशन कॉस्ट, जो भी खर्चे इस प्रोसेस को चलाने में लग रहा है, सबसे पहले उस चीज को दिया जाएगा, उसके बाद किसी सिक्योर्ड क्रेडिटर या वर्कमैन को दिया जाएगा। क्योंकि जब तक हम उस प्रोसेस के पैसे को पे नहीं करेंगे तो वो प्रोसेस चलेगा कैसे, राइट? तो पहले उस प्रोसेस का पेमेंट, फिर फाइनेंशियल क्रेडिटर का पेमेंट, फिर वर्कमैन का पेमेंट, फिर ऑपरेशनल क्रेडिटर की बारी आती है, जो मोस्ट ऑफ द केसेस में ऑपरेशनल क्रेडिटर को ना के बराबर पैसे मिलते हैं। कुछ केसेस में मिलते हैं, कुछ में नहीं मिलते हैं, कुछ में बहुत कम अमाउंट मिलते हैं। अगर उनके क्लेम 10 लाख के हैं तो मुश्किल से 5,000 10,000 ऐसे भी मिलते हैं, कितने केसेस में नहीं भी मिलता। तो ये एक गैप है बिटवीन फाइनेंशियल क्रेडिटर एंड ऑपरेशनल क्रेडिटर, जबकि उनका भी उतना ही रोल होता है, उतना ही योगदान होता है इस कंपनी को चलाने में जितना एक फाइनेंशियल क्रेडिटर का होता है। विदाउट गुड्स, विदाउट सर्विस, यू कैन नॉट रन अ कंपनी, राइट? जस्ट लाइक मनी, मनी इज important to run a company. That's the same thing. Without goods or without service, you cannot run the company. If a company is in manufacturing sector and they need some steel or steel ore or iron ore, so the other party who providing them the ore, they are the key person. But when company comes into the insolvency, they get the less priority. This is the difference. This is the gap between financial creditor and operational creditor. So they have to face that challenges. In fact, in a case it was challenged, but the Supreme Court has already clarified that the financial creditor has the commercial wisdom. They are the one who can think how to run to revive the company and everything. So they are still on the top of the pedestal in comparison to the operational creditor. And then the after operational creditor, the government dues, whatever the dues the government have been claimed, they need to be paid. And then after the other claims, if there is like leftover, then they needs to be paid. But in most of the cases, they did not get any single penny, any amount, because most of the amount has to be distributed among the workman dues, CRP cost, or liquidation cost, or the financial creditor, secured financial creditor, unsecured financial creditor. So all those are the main key person there, and the liquidator or the RP has to pay to them. So this is the waterfall mechanism which we generally follow, which is established by the law. So in liquidation, the delay, major reason of the delay of any either insolvency or liquidation is the litigation. I'm handling several cases where I have seen every assets of the company has been sold, everything has been done, all the payments has been made to creditors or with whom we have to distribute. The distribution has made, asset has been sold, everything has been done, but the litigations are pending. And the judicial system, we get the dates on after 3 months, 4 months, or 6 months. So due to that, that process been extending day by day, day by day, day by day. It's been getting extended too far. I have seen cases. In fact, I'm working on those cases which are being extended which is continuing from last 3 to 4 years. So, but as per law, what law says that has to be completed within maximum 330 days, including litigation time. As per law, it is only 270 days, 180 plus 90. But in several judgments, it has been said to consider up to 330 days, including litigation trial periods. But in reality, it does not happen. It takes more than 3 years, 4 years, 5 years, and still continue. So these are the loopholes. These are the gaps. As of now, there is nothing can be can be done on this point because litigation is, and then there are several cases pending before the court. Court also have to consider every cases. So due to that, the case time period of the liquidation of the CIP get extended day by day. So in these two things, there is one more important thing I wanted to cover for you, and it will be important for students, those who are in their final year. So they, I mean, you must can get questions in the exam related to personal guarantor. The personal guarantor is the person one who extends guarantee against seed. For the example, I'm a person who taken loan from the bank. So bank need the security. So some other person, so let's say Malvika, who have extended that I will be repaying amount. Yeah, she have given some assurance that she will be repaying that amount in case of I make default. So once I make the default, CIP has been initiated against me. That is true. But the court has, in several cases, clarified that if the default has been made by the corporate debtor or the lender, by the borrower, the corporate person, I mean the financial creditor, have the right to initiate CIRP against the personal guarantor. So now the CIRP can be initiated against the personal guarantor along with the borrower, principal borrower. So there is separate section which covers the personal guarantor, which you need to focus as well because this is the prime topic. In fact, the recent amendment also talks about the same thing. So there might be a question in your exams related to personal guarantee things. So you need to understand the difference between CIRP liquidation and then CIRP against the personal guarantee, how it is different. So that you can answer well in your exam. This is important. So you have to, read about it, about the personal guarantor, about the difference between liquidation and okay. So just before that, let's make it more engaging. Anyone who can make me understand the difference between CRP and the liquidation. So I have informed you various things about CRP and liquidation. So I wanted to know from anybody what is the difference between CRP and liquidation.
The CIRP's whole process of initiating the process of recovery and revival of the business, while liquidation is the last step under the CIRP where everything else fails.
Right,
Yes, CIRP can continue if the proceedings are on. Liquidation means that the company has to go under liquidation. Company will be auctioned. Whatever are the assets, they will be auctioned. And CIRP means that there is still some scope for the company to find another buyer or for someone to take over the company. But liquidation means kind of game over. Like,
right. That's true. That's true. In
yeah,
liquidation means the binding of the company. We have,
correct.
but there are several examples. Like recently, I have worked on a matter that is Birla Kotsin. The company was in liquidation, but we sold the company in the scheme of compromise and arrangement. And now the company is not liquidated. The company has been sold to some other one, some company.
Okay.
So that company will be revived again in the name of Birla Kotsin. Everything has been done. In fact, that company is listed company. Their share has been also been informed to the BSC, NSC, everyone. So that company which was in liquidation, which was on the verge to dissolve, we made that company successful and we sold that company. And now the company started running their business. The name
Okay.
is Birla Cotton. Recently, we made grand success in case of Visa Power. So that company was also in liquidation.
Visa
We
power.
sold, yes, Visa Power. It's also a limited public company. It's a listed company, but it's a public company.
Okay.
So we made the grand success. We sold the company assets and also sold the company as a going concern. Going concern means anyone can explain me what is going concern? Company as a going concern. Going concern is something where you company you can take the company's name, company's books of account, company's litigation, whatever the
Correct.
company has, that has to. Yes, fine. Please go ahead.
Yeah, yeah. So going concern, yes, as you rightly said, the company is still active. The company is still doing its operations,
Yes.
and the company is still operating as a business as usual.
Yes. So we sold the company as a go. So there are several examples, several cases where we have made this case. We sold the company as a going concern, but recently IBBI came up with the new rules that now in the liquidation, company cannot be sold as a going concern. Why? If the company has to be sold in the going concern, then why not that thing has to be done in the CIRP? The main objective of the CIRP process is to sell the company as a going concern in the resolution plan. But there we failed to sell the company as a going concern, and now in liquidation we are selling the company as a going concern. Why? Because the price of that value of that asset has been reduced. So this loophole was there, that in CRP there was a huge amount, value of the asset was huge, so that is why no one came forward, or whatever the reason was there. And in liquidation, of course, the value decreased. Once the company went into liquidation, the value of the asset, well, generally it's been a decrease, but in my case, which I talked to you about, Visa Power, that was really great, successful, where we sold the assets of 200 crores to the more than 650 crores. So there are several examples, there are several cases where these things happen. So that's true. The liquidation is the last resort, and from now onwards, after the order of, IBBI rules, no company can be sold in liquidation. That has to be, has to be sell the assets, and they have to be dissolved the company. So this is the one of the gaps which has been fulfilled by the IBBI. The bridges have been made by the IBBI to differentiate between the CIP and the liquidation. Anyone have any more questions?
So what you are saying is that no company will go under liquidation. They have to be, even if they are to be wound up, the assets are to be sold separately. All separate. All. Is that what you're
No,
saying?
I said if a company went into liquidation, that has to be sell all the assets of the company and to dissolve that company, to file the dissolution application. Now, the any company which went into liquidation, that has to be dissolved. That
Okay.
they cannot sell the company as a going concern. If that thing has to be done, then do that in the CRP process only.
Okay.
Once liquidation started, you cannot sell the company. Now you have to dissolve the company, because the main objective of liquidation is to dissolve the company.
Okay.
Yeah.
Okay. So if the company is to be revived, if the company is to be given to someone else, it has to be done under the CIRP itself when
Yes.
the matter is before the NCLT.
Yeah, that has to be done before the initiation of liquidation. I mean, in the process of CIRP.
Okay. Okay.
Yes.
And if it goes under liquidation, it has to be dissolved compulsorily.
Yeah. From the recent IBBI rules, the company cannot be sold as a going concern.
Okay.
There is no, there is no bar on scheme of compromise and arrangement as of now, but let's see how it goes in future.
Okay, so if the company is under CIRP, so at what stage of CIRP can it be can at what stage of CIRP can it be sold or be taken over?
So in CRP, RP made a publication that expression of interest. Anyone who is having interest
Okay,
in presenting a resolution plan. So there are several resolution applicant, 2, 3, 4 person came forward. They present their plan. जिनके भी वैल्यू ज्यादा होते हैं, जिनके भी पेमेंट कंडीशन सबसे वायबल होते हैं, कि हाँ दिस प्रोसेस इज इजी टू टेक द मनी, दिस प्रोसेस इज डिफिकल्ट टू टेक द मनी, यहाँ से पैसे लेना टफ है, यहाँ से पैसे लेना इजी है, या इनके पैसे ज्यादा है। तो जो सीओसी के मेंबर्स होते हैं, दे कंसीडर ऑल द फैक्टर्स, कि क्या उनके लिए वायबल है, क्या इजी है, क्या प्रॉफिटेबल है। उस हिसाब से वो प्लान को एक्सेप्ट करते हैं, एंड दैट कंपनी टेक ओवर द चार्ज, टेक ओवर द कंट्रोल ऑफ द एसेट of the company, and they need to make the payment, and the RP will distribute all the payments among the creditors and making the CRP dues as well.
okay, understood. But in any case, Section 53 of the
53
IBC.
generally follows in liquidation, na? Yeah,
Yeah,
but
yeah.
once payment came, then in CRP as well, 53 follow.
Okay.
Yeah. Once you get the payment from resolution applicant, SRA, successful resolution applicant, RP will distribute that amount in accordance with the section 53.
Okay.
Yes.
Okay.
Mhm.
Understood. Thank you.
Yes.
So now we see that the Videocon company is no more now. So that company is liquidated.
It's not necessary. Sometimes company itself dissolution, like there is a voluntary liquidation process. So in that thing, the company from their self say that ki, I'm not in the objective of my company has been fulfilled. Yeah, if the company is not in position to run the company anymore, so we want to dissolve this company. But before filing the dissolution, there should be no debt against the company. उनके अगेंस्ट कोई भी ड्यूज ना हो, उनके अगेंस्ट कोई लिटिगेशन ना हो, कंपनी के अगेंस्ट कुछ भी ऐसा ना हो जिससे प्रॉब्लम क्रिएट हो, then only the company can be dissolved. That is called the voluntary liquidation. But there is nothing related to Videocon or Paytm. Paytm is still running. Maybe you may be confused about the Byju's. Byju's was in place, but recently it went into the CIRP and is still in the process. Now the Byju's has been under the CIRP process.
Hi. My question is, if a company is under CIRP process, right, and there is a, resolution applicant which has taken over now the company operations, but the earlier company which is under CIRP was also having parallel proceeding in the civil courts like session courts and other courts which has not passed any judgment during the moratorium period. So my question here is, when the resolution plan has been finalized and the new entity has taken over that new operation, if any order is passed by the court, right,
Clean slate theory. That is called clean slate theory. The court will pass an order that
right,
any proceeding against the company will be dissolved. This company will be the fresh, except again anything which is against the promoter. If anything is against the promoter, that will be continued.
okay, so these cases, pending cases, automatically get closed by the
Yes, if it is against the not the criminal cases, which is against the either criminal or civil against the promoter. The cases against the promoter will be continued, but anything will be against the company, like any dues against the company, if any recovery proceeding is against the company, they have to file their claim. They will get the payment as per the waterfall mechanism, but not with the other medium. That is the purpose of moratorium. And after getting the company sold to any RA, resolution applicant, successful resolution applicant, then after the clean slate theory come into the picture, any cases which is pending against against the company will be strike off, and the company will start it afresh. That is called the clean slate theory, and a fresh start given to the company to run it again.
got it. Thank
Yeah.
you.
Rituraj, individual resolution process. Can you shed some light on that?
Individual, so that is against the personal guarantor or the individual, you say PRP. So that is initiated against the guarantor. So if someone has given guarantee, extended guarantee against the borrower, so the financial creditor or the operational creditor, whatever, is it's generally against the financial creditor, secured financial creditor. So they can initiate the CRP in the same process which they have made in the CRP against the borrower. But there is different section. In CRP, for the borrower, it comes under section 7 by the financial creditor. But in for the personal guarantor, it is section 295, I guess, where the CRP initiated against the insolvency proceeding initiated against the personal guarantor. So the process are the same. There is also moratorium period. There is also appointment of an RP. Yeah, the same RP continues to do that work, and the same thing happened there as well. But in what happens in personal guarantee thing, the personal guarantor generally say that ki I don't have anything to make the payment. I don't have any assets on my name. So you can initiate, you can, you can do whatever you wanted to go ahead with the further action. So once they say ki they don't have to pay, first we ask for the repayment plan. If they have some repayment plan, they can repay. If they don't, they need to specify that they have no repayment plan. They are not in position to make the payment. So once they affirm that they are not in position to make the payment, So we go for bankruptcy order. Once bankruptcy initiated, then the whatever the asset is in the name of guarantor, we sell that asset, either it's TV, phone, car, anything except essential item which is used for daily life, apart from not like mobile or any fancy things, that has to be sold in the bank after bankruptcy order, and that amount will be recovered from that personal guarantor. This is the process for the against the personal guarantor, and this is how the bankruptcy come into the picture. Yes, Sahil, please.
Yeah, I have two questions. One,
Mhm.
how do you enroll yourself, or what is the qualifying criteria to become an insolvency professional? That
So
is one.
insolvent, I'm not the IP. Let me clarify you. I'm not an
Okay.
IP. I'm an advocate.
Okay.
Uh, I'm practicing in insolvency from last 2+ years. For an
Okay.
IP, there is a 10-year practice mandatory. Then anyone can, give exams for insolvency to become an insolvency professional. But apart from that, there is new course that is IICA is offering, Indian Institute of Company Corporate Affairs. They do offers 1 year course, PGIP course, postgraduate insolvency professional course. They offer from the IICA. After qualifying that exam, you go and study there for 2 years. I guess 2 years. That is 2 years program. Then directly you can become an IP without 10-year experience. This is the
Okay.
course being offered by the IICA. But if you don't want to go into that course, because many people cannot afford that much fee, like it's 10 to 15 lakh fee. So many people practice for the 10 years. After that, they give exams for IP, and then they get enrolled. If they qualify, then they get enrolled as an IP. There is separate exam for registered valuer as well. So they are the process.
Okay. And how do the matters come to you? Like, because if you're an insolvency professional, one way is that the court appoints you as an insolvency professional for a particular matter. Is there any other way how the
Yes,
matters come to
yes,
you?
yes. So those creator who file an application, they also propose a name of an RP or IRP.
Right.
जब आप एप्लीकेशन फाइल करते हो तो आपको साथ में एक आरपी का नाम प्रपोज करना होता है कि हम इनको अपॉइंट करना चाहते हैं एज अ आरपी। और कोर्ट उस टाइम जब ऑर्डर पास करती है सीआरपी इनिशिएशन का, तो साथ ही साथ उनको एज अ आरपी आईआरपी अपॉइंट भी करती है। एंड आफ्टर सीओसी अब उसको आरपी को कंटिन्यू करना है नहीं करना है, दैट डिपेंड ऑन द सीओसी। बट
Okay.
फॉर
Understood.
दैट टाइमिंग पीरियड, दैट person whose name has been recommended by the creator becomes the IRP.
Right. Understood. Thank you.
Rituraj, one question in the registration form. What, according to you, is the future of IBC in India?
It's a very emerging code. Day by day, getting more and more, loopholes. Discovering many kinds of gaps between the code, and still the country is working on it. Every year, up to year or 1.5 year, we get some kind of new amendments. Why? Because the code is getting more and more, wider. The most important thing is getting in this amendment is cross-border insolvency. So now the insolvency can be initiated against someone who is not in this country. That is cross-border insolvency, which needs to cover as per the UNICITRAL model. So that is also being getting codified. This is also the few important reason to see that कि क्या ग्रोथ है अभी आईबीसी में, कैसे कितना आगे जाने वाला है। जब क्रॉस बॉर्डर हो जाएगा तो इसकी वैल्यू और बढ़ जाएगी, और केसेस और भी सारी चीजें बढ़ेगी जब ये क्रॉस बॉर्डर भी चलने लगेगा। अभी क्रॉस बॉर्डर इंसॉल्वेंसी हो रही है बट कम हो रही है क्योंकि प्रोसेस अभी क्लियर नहीं है। अब इस अमेंडमेंट के बाद हम इस चीज को और क्लियर करेगी हमारी लेजिस्लेचर, तो और स्ट्रीमलाइन हो जाएगा प्रोसेस, तो और इजी हो जाएगा इस चीज को समझने में, इस चीज को प्रोसेस करने में। दूसरी चीज कि जो भी कंपनी है, डेट हर एक कंपनी डेट लेती है, किसी ना किसी से फाइनेंशियल डेट लेती है, बिजनेस लेती है, सर्विस लेती है, और हर दिन ऐसे कंपनी आते हैं जो डिफॉल्ट करते हैं। न कंपनी कभी बंद होगी न डिफॉल्ट कभी बंद होगा, और जब तक कंपनी रहेगी डिफॉल्ट होगा वहां पे आईबीसी होगा, तो इनके केसेस हमेशा रहेंगे। तो इसमें ग्रोथ हमेशा है, इसमें इसका फ्यूचर और बढ़ने ही वाला है, क्योंकि अब जब क्रॉस बॉर्डर आएगा तो और चीजें ऑलरेडी प्रोसेस में, बट और जब ज्यादा इजी हो जाएगा और ज्यादा प्रोसेस स्ट्रीमलाइन हो जाएगा तो और ज्यादा एनहांस हो जाएगा ये सब्जेक्ट, ये कोर्स। तो आई मीन एनीवन हैविंग इंटरेस्ट दे कैन फोकस ऑन इट, इट्स अ वेरी ब्राइट स्कोप, दे हैव वेरी ब्राइट स्कोप इन इट, काफी अच्छा स्कोप है इसमें, काफी अच्छा फ्यूचर भी है इसका। तो फोकस ऑन दैट। तो इट इज इम्पोर्टेंट टू फोकस फ्रॉम द, अभी तो थ्योरी पे ही फोकस करो, बट व्हेन यू कम इनटू प्रैक्टिस तो उस थ्योरी के साथ साथ प्रैक्टिकल एस्पेक्ट पे भी ध्यान रखना पड़ेगा। तो इस चीज को अभी से एटलीस्ट अपने सब्जेक्ट पे तो कमांड बना के ही रखो। इट्स सजेशन फॉर एवरीवन। एनीथिंग एल्स, एनी क्वेश्चन और एनी
One
डाउट?
more question from registration form. Why do the insolvency suits take so long to settle?
See, the main reason is the litigation. सब कुछ हो जाता है, इंसॉल्वेंसी इनिशिएट होने में ज्यादा टाइम नहीं लगता है, थोड़े टाइम लगते हैं, बिकॉज जो अपोजिट पार्टी होते हैं वो काउंटर करते हैं, उनके बहुत सारे क्वेरीज होते हैं कि हमने ऐसे किया, हमने ये डेट ऑलरेडी पे कर दिया, इतना डेट बचा था। इस वजह से भी डिले होते हैं, वो भी लिटिगेशन का ही पार्ट है। तो मेजर जो डिले होता है वो लिटिगेशन की वजह से होता है। दूसरा डिले होता है वैल्यूएशन की वजह से, कि जब हमारे पास कस्टडी नहीं आती है प्रॉपर्टी की, क्योंकि जो प्रमोटर होते हैं, एक्स प्रमोटर कंपनी को, वो सपोर्ट नहीं करते हैं। वो एक्चुअली एज पर द लॉ उन्हें हमें कोऑर्डिनेट करना है, हमें फुल अपना असिस्टेंस देना है, बट जनरली वो ऐसा करते नहीं है। कभी कहते हैं यहाँ नहीं है, ये नहीं है, ये चीज खो गई या मिल नहीं रही, बहुत सारी रीजंस देते हैं जिस वजह से डिले होता है। तो ये सारी चीजों की वजह से काफी डिले होता है इस प्रोसेस में। और 330 डेज क्रॉस करके 550 डेज, 650 डेज कब चला जाता है पता नहीं चलता। बहुत लोग क्लेम बहुत दिन बाद करते हैं, जनरली 30 दिन में करना हो तो लोग 100 दिन बाद, 200 दिन बाद भी करते हैं। एंड वी हैव टू एडमिट दैट आफ्टर एनसीएलटी ऑर्डर। तो वो भी एक क्योंकि उनका भी जेन्युइन होता है, कुछ लोगों का रीजन कि कोई हेल्थ को लेके हो गया, कभी उनको इंटीमेशन नहीं मिला, इस वजह से हो गया। तो काफी सारे चीजों की वजह से उनको क्लेम हम जब रिजेक्ट कर देते हैं, बाद में कोर्ट से एडमिट करा लेते हैं, तो उस वजह से भी डिले होता है। तो ये सारी रीजंस हैं डिले के।
Okay. I think Rituraj, we are done. Can we conclude?
Okay. Sure, sure. So, it was really nice to having you all guys here, and I hope I tried to convince you about some basics part of the IBC. And we are the future now. We need to see the gaps between the IBC and the practical aspects, and we need to fulfill that. We need to fulfill that gaps. We need to raise our voice against कि कैसे उस चीज को हम ठीक कर सकते हैं। IBBI आस्क फॉर रिकमेंडेशन एज वेल, अगर जहाँ भी कुछ लूप होल्स होते हैं तो वो रिकमेंडेशन लेते हैं हम लोग से, लॉयर से। एंड दे डू कंसिडर, अगर उनको वो चीज लगती है तो। ये जितने भी IBBI अमेंडमेंट वगैरह आते हैं वो सारे रिकमेंडेशन के थ्रू ही होते हैं, क्योंकि जो भी लॉयर्स होते हैं वो अपना रिकमेंडेशन रखते हैं, आर्टिकल वगैरह लिखते हैं, उस चीज को प्रेजेंट करते हैं वेबिनार वर्कशॉप वगैरह में। तो वी आर द फ्यूचर, वी नीड टू फोकस ऑन दिस, कि कहाँ पे इस चीज को, जो लूप होल्स है उसको कैसे ठीक कर सकते हैं, अपना सजेशन दे सकते हैं, अपना ओपिनियन दे सकते हैं। दैट्स डिपेंड ऑन द IBBI, वो कैसे इस चीज को कंसिडर करते हैं। दैट्स इट, थैंक यू।
Thank you so much for bringing that to our notice, Rituraj. How can they get in touch with the authorities?
थ्रू देयर पोर्टल वेबसाइट, IBBI के पोर्टल पे दे दे
And there
मेक
are
अनाउंसमेंट।
regular notifications.
यस यस यस, हमेशा आते रहता है। आप यू कैन विजिट एनी टाइम, एनी डे, यू विल सी देयर इज नोटिफिकेशन विद रिगार्ड टू समथिंग। यू कैन दे डू पब्लिश डिस्कशन पेपर, जिसमें जो भी अमेंडमेंट करने वाले थे वो पहले एक डिस्कशन पेपर निकालते हैं, उस पर आप अपना ओपिनियन दीजिए, एंड दे विल कंसिडर इन द फ्यूचर। तो काफी अच्छी प्रोसेस है, अगर हम उस चीज को कम्प्लीटली फॉलो करते हैं तो।
Okay. Okay, Rituraj. So I think we can conclude the session. Thank you so much for such a wonderful webinar. We got so much clarity on the subject. Thanks again for such an illuminating session.